Okay, guys, this is another episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. So, in this episode, we are going to talk about strict liability, and this is a subtopic under the unit of the law of torts. So, we are going to look at what strict liability is, the elements of strict liability, the locus classicus case, the case that establishes the principle on strict liability, that one of RYLANDS versus FLETCHER, and the requirements that were brought out from that case of RYLANDS versus FLETCHER about strict liability. And we're also going to look at the exemptions or the defenses that someone might raise under strict liability. So, strict liability, this refers to the liability without proof of fault on the part of the wrongdoer. The wrongdoer is not supposed to prove whether or not he had fault in committing a particular offense or crime. So the wrongdoer is automatically liable whether or not he had fault in committing that crime. This is the liability without fault. So the prosecuting side has that obligation to show that it incurred damages as a result of the defendant's action. So if the prosecuting side is able to show that damages was caused as a result of the defendant's action, whether or not the defense side had fault in committing that particular crime, that side is automatically liable under strict liability. So under normal circumstances, for example, a case of negligence, a party is supposed to show how it had duty of care. That the prosecuting side is supposed to show how the party had a duty of care and how that party breached the duty of care that resulted to damages. But under strict liability, that's not the case. Whether or not you are negligent, you are just strictly liable. It does not depend on the negligence or that negligence thing. So a party is strictly liable whether or not that party had fault in committing a particular crime. We also have those strict liability crimes, and a strict liability crime is a crime that only has the actus reus but not the mental state. Those are crimes that only have the actus reus. So if you are able to show that a crime or an act was committed, then that crime ends there, because that mental state is not required under strict liability crimes. So this strict liability is based on the neighbor principle, and when you are rearing something, you are supposed to keep that thing at your own peril, and keeping that thing at your own peril means that you are keeping it in a manner that it's not able to interfere with your neighbor. For example, if you are rearing a dog, you are supposed to make sure that you keep that dog at your own peril, keeping it in a manner that this dog is not able to escape and cause mischief to your neighborhood. So if this dog escapes your neighborhood and causes any form of mischief, you are then liable under strict liability. If your neighbor sues you, then you will be liable, because you are supposed to keep that dog under your own peril. Whether or not you had fault, you are strictly liable. If you are rearing monkeys and your neighbor and in your neighborhood they are cultivating bananas, you are supposed to keep those monkeys at your own peril, keeping them in a manner that they are not able to escape to your neighborhood and cause damages to the neighborhood's plantation. So that is the requirement of strict liability. You are supposed to keep something at your own peril in such a way that it's not able to escape to your neighborhood and cause damages. So the law that establishes the rule of strict liability we refer to as the locus classicus case, and that is the case of RYLANDS versus FLETCHER. A locus classicus case is a case that establishes a particular law. So the case of RYLANDS versus FLETCHER is an example of a locus classicus case, and a locus classicus case is a case upon which a principle of law is established. So another example of a locus classicus case is the case of Donogh versus Stevenson, and it's this case that the principle of negligence was extracted. So locus classicus case is that case that establishes a principle of law. So the facts of the case in RYLANDS versus FLETCHER, the case that establishes the law on strict liability, are Mr. RYLAND had a mill and wanted to supply water to this mill. So Mr. RYLAND hired an independent contractor or an engineer who was to build a water reservoir that was to supply water to the mill. So this engineer came, identified the spot where he was to construct that particular reservoir. So Mr. Fletcher had a coal mine just adjacent to Mr. Ryland's mill. So Mr. Fletcher had dug 5 vertical shafts that he used for mining that particular coal. So when this independent contractor came, he did not warn Mr. Ryland about those vertical shafts. He just identified the spot and constructed the water reservoir. This is an 1860 case. So he constructed the reservoir. So those vertical shafts were filled with some soil, some rocks, and some timber, so it wasn't visible. So this independent contractor or engineer constructed the water reservoir but did not warn Mr. Ryland about the vertical shaft. So when he was constructing the water reservoir, one of the vertical shafts collapsed, and water fled and filled the coal mine, the Mr. Fletcher's coal mine. So Mr. Fletcher was forced to abandon the entire mining site, and he incurred losses as a result because he wasn't able to mine again. So he went and sued Mr. Ryland for the damages that he incurred. So the trial court ruled in favor of Mr. Fletcher, but it was further reversed in the Exchequer chamber, in that the court ruled that Mr. Ryland wasn't aware that there existed a coal mine just adjacent to his mill. So the Court of Exchequer reversed the rulings in the trial court. So the case was further appealed in the Exchequer chamber, whereby the ruling in the Exchequer court was overturned, and the court held that Mr. Ryland was liable because he possessed a dangerous thing. So under this rule of strict liability, it demands that when you are not supposed to possess a dangerous thing. When you possess something that is so dangerous, you must keep it at your own peril, so that it is not able to escape and cause harm to other people. So he kept a dangerous thing in his. He was in possession of a dangerous thing that caused damages. So from this case of Rylands versus Fletcher, there are 5 things that are brought out for a strict liability to apply. First of all, there must be a thing, and this thing must accumulate. And after this thing that accumulates must be in a natural use of land, and it must escape and cause damage after escaping. So those 5 things are brought out from this rule of Rylands versus Fletcher. There are requirements in the rule of Rylands versus Fletcher. The thing must accumulate in a natural use of land, escape, and damage. So under the thing need not to be dangerous. Even the most harmless thing can constitute to a thing. And here things like electricity, water, poisonous leaves can be included as a thing. So this thing must accumulate, it must have stayed for quite some time, and it must be in a natural use of land, not permanent use of land. So those things that are as a result of nature are not included under this rule of Rylands versus Fletcher in strict liability. So those that are in a natural use of land are the ones that are included. So the thing must escape. One of the requirements in the rule of Rylands versus Fletcher, the thing must escape, and after the escaping, it must cause damages. So you must prove damages from the escape of that thing. If you're not able to prove damages, then that rule will not favor you. So there are limitations or exemptions to this rule of Rylands versus Fletcher. First of all, the first limitation is that of consent. If you had consented for that water reservoir to be constructed, then you cannot sue under this rule of strict liability. Another limitation is that of contributory negligence. Is also a limitation to this rule of Rylands versus Fletcher. Another exemption is that one of if the both parties had agreed that site that's about consent. So let me. The defense is the act of God. common benefit. If that thing was to benefit both parties, then those parties cannot sue for strict liability. And another one is the act of stranger. For example, if a stranger came at your homestead and tied the dog, and the dog went and committed a crime, then you cannot sue for strict liability because it's an exemption and it's an act of a third party or a stranger. That's just the same, like the same way an independent contractor is different from Mr. RYLANDS. So the act of a third party or a stranger is also a defense and statutory authority. You know, government bodies are included as statutory bodies, and if a government intends to construct something, or you cannot sue the government. A government is an independent body, and it's a statutory body with statutory authority. So it's also an exemption to this rule of strict liability. So the elements under strict liability, the defense side must prove that that thing was brought and that thing that caused damages to the plaintiff. So I think that is the end of my episode of Scott Talks Law and my episode of my lecture. And you can subscribe to Scott's Legal channel. You can comment on the comment section about how you feel about the lectures. When you find the lectures to be interesting, don't just be silent. Equity aids the indolent. So you can just comment on the comment section on how you feel about the lectures.